testing that has been done that has reached that conclusion? Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This again is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
Thompson?
Thank you, Your Honor. And as the court is aware from the responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right. The standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today. And I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label.
Good morning, everyone.
Absent evidence, competent forensic evidence, if you will, qualified expert evidence. And I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things. But for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well.
Hey,
With
2112.
respect to inflammatory evidence, I don't know what that is until I see it. Certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say, don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, the state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court prefers.
Let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit it to the
I think
court
it's
on
the
the
defendant's
filings.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger, or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions. And that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of better term, ruling or instructions about argumentative comments or statements of counsel.
Thank you.
The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, One of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020,
It's a bad act?
it's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan
That's
to use
how you
that
can use
paper.
it. It's,
I'm sorry, I can't hear you.
that's how you can use it under 404. The way you can't use it is a prior, the term of sort of colloquial term is a prior bad act to show that the party acted in conformity with that, that they've propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene.
You guys,
So
that
our
large
position is that we
document.
don't want to make sure that there's not some sort of in run. The same example that I will give you has to do with
Help me
the
understand here.
Amazon
I
records.
don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is in essence trying to anchor it to a bad act without giving notice of that.
I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
Like the knife.
It's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
That is
Yeah,
not what
none, yeah.
404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice. They should not be able to argue evidence is a prior bad act or make any attempt at an in run on that rule.
So I'm not understanding what you mean by an in run on that in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th.
Yeah, the murder weapon.
2022, for the purpose of making a plan.
Very.
And that's the argument that the state will make about that.
Yeah, premeditated.
I mean, I think I understand what you're saying. I just think we're
So I think,
completely missing
okay.
each other's understanding of the rules of evidence.
Right, that's
Well,
not
I
rule.
still stand by my
401B.
position that the state should not be able to in run that. And I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they
Hi, Kelly.
intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do
Okay.
you want me to go to the 404B on the video or
On
keep it
the, on the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience.
Okay.
It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples.
Please do.
In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think state seatbelts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So
Of
it's
what year?
of 2022. So it's remote. It's
Before the murders.
yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Yes.
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, I can't remember the name, the maker.
Hyundai Elantra.
Hyundai Elantra.
Right.
And that he, as opposed to others, drove that vehicle.
Correct.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and And then there's going to be other videos that are put into evidence.
Right.
There's a different argument to be made as opposed to someone verbally reporting a make and model. The state has, the state
That
is,
sounds like that makes the evidence of, I guess I'm just not tracking again under 404, how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is
Right.
kind of what we were talking about, which is 403. I haven't heard anything that's 404, but
okay, well, they've noticed it as 404B evidence. So
traffic stop.
I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity.
But you don't get
his
to, and
phone
I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that
Oh!
evidence. And when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument.
What? Okay.
We ask that you exclude this video.
Exclude the
which
traffic
I will
stop.
ask that it be, that the marshal provide that to you and that the state use a different method of proving identity.
Proving it puts Kohberger in the car right before the murders, guys, in August for the traffic stop. It's perfect. It's clear. It has him speaking. Of course, they don't want that in because it shows him driving around the Moscow area in the Hyundai Elantra.
After what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it.
Yep.
The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence.
And these were in the motions.
Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it, first you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so can you address that part of it, the prior bad act, and how the court should deal with that? And then also I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate your Honor's comment. I think when you review the video, you can the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt
It was a
somehow
traffic
means
stop.
that he is guilty of murder. That's a preposterous concept.
Mhm.
And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. That's beyond a stretch of imagination.
Yeah, that's a big
Does
leap.
that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or non of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts
The
in
traffic
describing
stop.
404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case, there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not substantial. I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404 or notwithstanding 404B and 403. I do want the video potentially, I'll look at it and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer. about, that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
So all the way to the left is Bika Barlow, then Bryan
All
Kohberger,
right, let's talk
Alyssa
about
Massett,
who
and
is
Taylor.
going to be in the courtroom amongst the victims and the defendant's family.
Okay, the family motion
in
in limine.
general, in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Exactly, Jamie. Exactly.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-061B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary.
Felt like it.
The
Pat.
language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged. The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, The prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, so it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder.
Okay.
He needs to have his family here to support him, and they need to be in the courtroom supporting him.
Because of his
These
autism. Oh my
needs
God.
are constitutionally protected rights.
He lived. Okay.
We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
He needs emotional support from his family from autism, but he lived across the state in his own apartment, driving his own vehicle, working. This is Ashley Jennings. Sorry, guys.
Your
They're
Honor, the
wearing
state
similar
trusts that
stuff.
This court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support
Is
Mr.
there a reason
Kohberger.
you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning? Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think
few
of
of
a
them.
reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a
Right.
jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Which means we'd rather call them first than have them sit and listen
Judge,
to
I
other
knew that the
witness
state's
testimony.
position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public. And there are cases, as I referenced.
Constitutional right is not absolute. It bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says that court can't use the exclusionary rule where in good faith a person who is otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family,
Oh my
who
God.
is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you.
That humanity.
I'm going to take this matter under advisement. The defense raised some cases. I want to read those. Though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course. Let's talk about the defendant's motion regarding conditions as an aggravator. And this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Okay, we got Am.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is.
So then say that.
We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
I assume he's not going to be talking in court unless he's testifying. So
Correct.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger. And that's what we don't want.
And the
We want
gloves that he wears.
To be able to
He's a
present,
clean freak.
if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do, how we deal with that with the jury.
Right.
In terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
Like no shower curtain, cleaning, gloves.
How would they use it as aggravating apart from arguing to the jury that, well, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that.
Exactly, Pat.
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Bryan,
No, say it.
against him, to say
The gloves, cleaning.
that he does things that are consistent with autism and
See?
that's an aggravating circumstance. That's
I'm just having a hard time envisioning.
He doesn't want to say it.
How it would be presented in a way that is making it an aggravator.
Cleaning, separating
Well, I
trash,
would
no
hope that
shower
it wouldn't
curtain.
be presented that way. But Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him.
Oh,
And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I go, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females.
Yep.
Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to, in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may no, that's not. That's his view of women and goes to motive, etc.
Right.
And goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want
I
me to,
wanna
you want
be
me to weigh in and
clear.
say what factual findings are that it's this and not that. And I'm not
Right.
sure I can do that short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
That's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present
There
mitigation,
may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Right. It's for the jury.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that
How so,
the
he
court
said.
will not find that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and
No.
it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says
No,
the
says
state
no.
can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that.
Yes.
I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to
His
if the
behavior.
defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so
Right.
the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation.
Because Anne is going to have everything go under that. You have to understand his behavior, what he said to people, his demeanor, any creepiness, any uncomfortability. Nope.
We
mention
understand that
it.
the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Right.
Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. The state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about.
Exactly.
I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with.
Yep.
And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. All right.
What are we getting next?
Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till.
Okay, good. I can finally talk to you guys a bit. All right, because I'm trying to keep my interruptions to a minimum. I know nobody wants to hear interruption. And so I'm finding myself muting, but still talking over it a little bit. Please let me know if it's too much. But okay, so where this is starting, and I'll be back in 10 minutes. And I'm not, she's doing her job, okay? She's doing her job. But here's the problem with that is in the motion in limines, and if this sounds familiar, this is all the motion in limines that me and Shay have been reading, right? The defense motion in limine, you know, like I want the aggravating factors. Yeah, I want the term psychopath completely thrown out. And then the state responds to the motion in limine, then the defense responds. It's all of the stuff that they don't come to an agreement on that now gets presented for oral arguments in front of Judge Hippler, and he's going to decide. Ultimately, this is a massive hearing. It's determining what evidence is or is not going to be allowed at trial. So here's the problem specifically with the autism, and this is what it seems like based on these motions, okay? Bryan at a school age was evaluated the way that every child is. Anybody who's a parent who has a child around like preschool, kindergarten age, usually before they go into elementary school, they get evaluated. And every child would have like an IEP. And it could come down to the way you hold your pencil, right? Your child holds the pencil. Hey, your child is not holding their pencil between the thumb and the pointer finger. Instead, they're kind of gripping it between the middle finger and the ring finger. Or, you know, your child, instead of sitting Indian style when it's time to gather around for reading, they're sitting with their on top of their legs with their butt to their heels, and they're rocking. That's could be symptomatic of possibly ASD. Hey, Wolfie. things like that. And so they will evaluate your child. And so when you go into the school age, you have your IEP, and hey, you know, like you could maybe get additional time for test. You could have, you could be in a classroom with a teacher's aide, like a student aide that comes over outside of just the teacher and give additional help. It could be a wide variety of things. And each year they're evaluated with their IEP. What it seems like to me is at an early age, Bryan had this evaluation done, right? And he probably had some of those markers the way that a lot of children do. A lot of children do. And so it seems like to me, he probably grew out of it, or he learned to deal with the symptoms and he never got additional treatment. I do not believe they are going to show any additional diagnosis other than that original evaluation at a very young age, because it even referred to not being able to tie his shoes at 4. Okay. Now, and thank you, Wolfie, for, oh my God, I think that's the longest I've ever seen it. 40 months. Thankfully, not a YouTube glitch with your memberships, and I have my full 40. That's crazy. Thank you. Right. And so I think, hey, Jane, now, you know, with the defense team going back and pulling up all of his records, and that would be in his school records, they go in and they use that, and they get him evaluated as an adult post murders. And that evaluation, I think that diagnosis, they're going to tie back in with that original evaluation showing that this goes back a long time. But I think it's going to be a good argument that he clearly was functioning and living and had no issue on a day-to-day basis. You have to remember, defense is arguing that he is not capable of even thinking ahead to the next day. He is not capable of functioning on a day-to-day basis. It's not like, hey, this just goes down to, well, yeah, he stares a little bit too long and, you know, maybe socially awkward. No, in their motions, they're literally saying he is not capable of thinking ahead. He is not capable of managing on a day-to-day basis. Yet, with that being said, his family had no problem with him moving across the country, living on his own, maintaining his own apartment, driving his own vehicle, working and attending school, running a classroom, grading papers. That is absolutely ridiculous. But here's what Anne's trying to do. Not only because she didn't want to say it in oral argument. When Judge Hippler's like, explain this better to me, right? Explain this better to me. Like, how are they going to use this as an aggravating factor? When she says, I don't want the state to mention or harp on these types of things, she's just not talking about, as they said, the hundreds of hours of recorded testimony of people, students who went to school with him, right? This isn't going to be just he was creepy and he was looking and he made me feel uncomfortable. This is going to turn into what we saw in the motion in Limines. He was a clean freak. You cannot bring up that he was wearing gloves. I don't want to hear that he was wearing gloves when they came in and swatted and arrested him, because that goes into his diagnosis. That goes into the ASD characteristics. He is a germaphobe. I don't want you to mention the lack of the shower curtain, because he is a germaphobe and he got that shower curtain changed every month. He would switch it out, switch it out, switch it out. So like, she's making it seem like, oh, well, I just, you know, I don't want it to be used against him. But no, if he signs that order, she could start to argue everything that is in characteristics of ASD. So she's going to, and what the Judge Hippler is saying, all right, you want this expert to get up on the stand and say, hey, X, Y, and Z are all characteristics and traits, or can be characteristics and traits of someone on the ASD diagnosis. So guess what? That means you could throw out a lot. You're telling me we can't bring in the fact that he was wearing gloves? That is a huge thing in this crime, right? Hey, he was wearing gloves. Why would he need to wear gloves? Hey, he was separating trash. Why would he need to separate trash? He was meticulously cleaning his car in the middle of the night. All the things like that, which it helps build this idea, right? It helps build a picture. None of that could be mentioned. That is where Anne's trying to go. And Judge Hippler's like, no. And the truth is, you could get one expert on the stand who's willing to say this and another expert on the stand who's willing to say that. That's why defense has their expert witnesses and prosecution has their expert witnesses. They don't all agree. That's why you get second opinions. Even when you go to a doctor, it's not as simple as a diagnosis, right? Every doctor you might get, you got to go for that second opinion. And so what I wish people would realize is, why, if Bryan is innocent, would defense have to go this far? And when I say this far, I'm not just talking about the ASD diagnosis. And I'm curious, like I said, I do not believe, this is my guess, there will be any documentation of any diagnosis other than an evaluation he got at a very young age, never sought treatment, never got another diagnosis. And it was only post murders that now that he's incarcerated, they had experts come in and give him an evaluation. But she, in totality, what I want everyone to realize, and we're going through each motion, they're hearing it, each motion. I'm really excited for like the 911 calls, the text messages, AT&T, timing advance records, and Amazon. It seems like Amazon is what we may came in. We were a few minutes late. I got to rewind to hear what they said, but none of it is focused on an alibi. And he's going for an alibi defense. Let me be clear. You do not need to go for an alibi defense. They are going for an alibi defense. Yet nothing is regarding an alibi. Everything Anne is arguing is that he is literally incapable, incompetent, which is really disrespectful, and it sets everything back as far as how far we've come with ASD and the knowledge, the general knowledge and awareness. And I feel like everyone's tried so hard, especially with mental health diagnosis, to not be labeled and put in a box, right? And that's exactly what you're doing now. You're coming back in and you're labeling and putting him in a box, and he probably doesn't even have a true diagnosis. Maybe he does. I don't know, but it has nothing to do with his crimes. But it is so much about technicalities and so much about, okay, well, if we do get to the point, like that he's convicted, this needs to be brought up because, I think that the jury would sentence him to death solely because of his ASD diagnosis, which is ridiculous. Hey, Twisted Stitches, it's absolutely ridiculous. Well, and it's interesting that two may be called as witnesses, and the way that the defense is making it seem is they do not want to be. Well, they don't have that choice. But I'm curious if they're speaking overall for all family or just mom and dad. I'd be really curious if a family member didn't tip them off. I don't know. I'm very curious about that Amazon, and if it was on a family plan, and if the family, because we heard reports about this very early on, not confirmed, but how his sister, something about his sister, okay? Little whispers, little talk about here and that. And that was on the 2020 documentary that Shay was looking for, remember? Hey, Jonesin, did the state move the testimony of the defense experts who's out? So they're not trying to bar the testimony of the defense experts, but they're saying we haven't gotten even all of the information. You're saying, okay, your expert evaluated him. He has level 1 ASD and 2 other, I forget what they're, but it comes down to the fine motor movement and stuff. But we haven't even received all of that information. So that's one thing, but they're not even arguing any of that. But they could bring in their own expert to give their own opinion. But to say that he was incapable of functioning on a day-to-day basis, and he is not capable of even thinking ahead and planning ahead, really? He got up every single day. He attended work. He attended school. Did he pay his bills on time? He had an apartment. He lived on his own. He had his vehicle. He lived at his own. How the hell can you say he wasn't able to even plan a day ahead? That is in the motions, guys. He is not capable of planning a day ahead. What? Yet he was a TA, he was grading papers, he was running a classroom, he was a student. And then they're also trying to get the DeSales how to handle a crime scene. And yeah, it sucks. It shows like it's a one-on-one of how to get away with a crime. All right, I get that the defense doesn't want that in, but they're not using it to necessarily show, oh, he's familiar with it. They're also using it to show he was competent, you guys. He was able to function. He is very clearly educated. But Anne is trying to make it seem like he's a little incompetent baby sucking on a mom's tit. Like, and I know that's too far, but like, I really don't care. That's literally how she's making it seem, that Bryan can't even verbally aid in his own defense. Do you know how far that is? Like, he cannot even verbally aid in his own defense. Really? And that's also why they want that traffic cam thrown out, the body cam. They want that thrown out because in August, months before the murders, it shows Bryan Kohberger driving in suspect vehicle number 1, and the phone number Bryan Kohberger gives and associates to himself in August 2022 to the officers is the same phone number that they pulled from the night of the murders. And it also shows that he is competent. He is driving and operating this vehicle. He is having an open discussion with the officers. He is aware that he has a traffic infraction. They want that out. They want that out. Right. Until the DSM-5, yeah. It's if he was truly innocent, and again, I'm not 100% anyway, but I'm just saying, if he's truly innocent, why do you think the defense needs to focus so hard on all this extra stuff? How about if you're going with an alibi, show he was not there. Show he was not there at the time of the crimes. He was elsewhere. Or else, why are you even going with an alibi defense? But defense is saying, oh, well, I cannot give you an alibi, which, you guys, this was years ago. They needed to meet that alibi deadline, which it puts you in another place with evidence at the time of the crimes. Well, we don't have that. Okay, our client was out stargazing, which I know, again, I tell you he was incompetent and wasn't able to do anything, but he often went for late night drives and he often took photos, even though it was a very foggy night that you couldn't see the sky. And I can't tell you specifically where he was or anywhere that may have clocked him driving. But what I can tell you is through examination of your expert witnesses, that is when I'll be able to prove his alibi. What? It's so disrespectful, Johnson, because again, I feel like Anne literally said the jury would not be capable of understanding autism characteristics and symptoms, that they would literally see that he sits pretty stoic or he has more of an expressionless face. And because of that, sentence him to death, which is absolute bullshit. And I'm glad Judge Hippler said he's not supposed to be talking anyway. You're sitting here saying, oh, well, he may talk more, or talk less, or this. Unless he is testifying, he shouldn't be talking during the trial anyway. But I feel like we have come so far, and everyone, for the most part, is very educated and aware of these symptoms and characteristics. And everyone has worked so hard to bring that awareness and to not label, right? Hey, I may have autism, but do not label me based on these characteristics or symptoms or traits. It's very common. There are so many people with an ASD diagnosis. It's very common now. And to act like the jury would not be smart enough to even understand it if it was explained to them is insulting. But you're taking how far we've gotten as a society and you're putting them back into a box, right? well, these are the symptoms, these are the characteristics, this is how you label someone with ASD, putting them back in the box, and you're using it as if it somehow is going to throw out all of the suspicious behavior he has. You know what I mean? I think it's wrong. I think it's messed up. I'm not going to say 100% certain he doesn't have an ASD diagnosis. I don't know, but I know that it does not parallel the crimes and his behavior. You can have a diagnosis and still be guilty. It does not go hand in hand with one another. It wouldn't be the reason. You are more likely to be the victim of the crime when you have a diagnosis like that, not the perpetrator. So it's very insulting, and it sets how far I feel like we've come back. Now, I'm really excited to hear the arguments regarding the 911 call and the text messages. I really want to hear more about these text messages and Bethany and Dylan in the early morning hours. And I'm hoping through oral arguments we get a little bit more of the information. Right, coffee and skeletons. But you know what? Again, if he wasn't the guy, I feel like there would be a little less focus on all the technicalities and all of, well, now we're turning him into an incompetent human. He wasn't. It's ASD 1, okay? Not to minimize, but I'm saying he was high functioning, if anything. Now it's turning into, ask yourself, why does Anne have to turn Bryan into someone who wasn't able to even plan one day ahead? Who wasn't able to function? He is not capable of verbally even aiding in his own defense. He can't speak to his own team. What? Why does he have to do that?
All right.
Because he's guilty, in my opinion.
Let's talk about what I hope we have come to an agreement is not an issue, which is the IgG stuff.
The IgG stuff, yeah.
If I may start, and they're battling.
Yeah, I think there are 3 motions. One is the improper expert
So
testimony.
this is
of
Bika
Middleman,
Barlow,
who's
guys.
related to the IgG. The defense, and that's the defense motion. Defense motion regarding IgG evidence generally, and then the state's motion regarding IgG.
Yes, good morning, you're right.
Genetic
Your Honor,
genealogy,
that
Sandra.
we have essentially, I think, an agreement with the state as to their position and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is how, exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Kohberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohberger, that set them on a train or a trail to charging him, was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to them investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
Right.
I apologize. You're true, right? It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence. And the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer. And the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. And it's not our job to tell them how to do that. but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, you know, we're not going to tell you what that tip is, and you don't need to consider it, or something like that.
Is that an invitation?
It's an invitation for you, two sides, to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments.
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes then we want, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury, and they can get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that. Right. And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do it. And I think that generally causes them to back off that. And so that's what I'm suggesting that you try to work through.
Okay, will do. Thank you. That's all I have to say.
I didn't mean to cut you off. If you have
No,
anything-
that's all I have to say. That was the only concern that was left for us.
All right. Thank you.
So the tip is the IgG and linking it through the ancestries.
I think that fairly states where we are. I was curious what the defense meant in their reply, where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in discussion about a jury instruction like the court outlined. I will comment that it seems like it took a long time to come full circle, because we're right back where the state started
Yep.
a long time ago, with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also, for the record, there were some pretty serious allegations, ethical allegations made
Yep.
by the defendant in its motion in limine number 11. Those
Framing.
were factually rebutted very clearly in the state's response. I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
Yep. That it was planted and shit.
Sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that.
I don't know, Harlot.
To me, this is a practical problem. Regardless of the reasons you are in agreement, the important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohberger that put him on the radar, right? And so I think that's just where you come. I don't think For those purposes, we're suggesting that the state can't present its evidence about the car, suspected car, about the defendant's whereabouts on the night, et cetera. Those are things that were discovered and put together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out. And if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and lead investigators, to simply testify that they received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
And so we have a pretrial in next month, and so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
All right, thank you. All right, that leaves in category A by my score sheet, the alternative perpetrator evidence, which is the state's motion in limine.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why do you stick that one in there?
I just forgot it.
Thank you, Your Honor. And this is actually a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do
So
that.
for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without meeting a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof, so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor.
So the alternative perpetrator limine.
So
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's
You
gonna
didn't
be
meet your deadline.
a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach.
Hey, Lisa.
I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
They did lower his chair, man. You guys are right.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers
Yes, Michelle. Over.
and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. So I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial since you're here to take care of that.
Thank you, Your Honor.
All right.
Bushy eyebrows.
And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub, to use the art of the craft involved. This relates more to allegations of somebody more specific, identifiable. All right. Let's talk about DNA, which is the inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third. I think the first two relate to the kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey the statistics that DNA analysts use to more real world comparisons to, for example, planetary population. The second deals with DNA that was found under one of the victim's fingernails and by the DNA analyst as to whether or not Mr. Kohberger could or could not be excluded. And then the third really deals with more sort of this labeling problem that we've already addressed in some fashion in different contexts of what labels should, can, and must we use as it relates to the quote unquote touch DNA that was found on the knife sheath.
Open to the public alley.
Yes, thank you. That's a great summary. And I'd like to start with the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question from the jury because their own analysts during the grand jury essentially told them that you can't do that
Hey, Chelsea,
given the
Pablo.
statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct. And it was my
Not
understanding.
in the way in which the question was asked that the witness sort of corrected the attorney about.
Correct. And the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore. And so by asking that question, you're triggering, you're conferring or not conferring, you're
Brian brides. Like Wade
speculating,
wives,
essentially,
Brian
put in front
brides.
of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Excuse me. The inconclusive data, I don't know if the court
You're
is
excused,
seeing
Barlow.
the late. I apologize. All of a sudden, my voice is
All right,
just
we can get you some
disappearing.
more.
Yeah, that's what happens when you're coughing up a bunch of bullshit, Barlow. Getting a little bit flummy in there.
I don't know if the court has seen the latest filing from the state.
I did see it.
Okay, so they filed a new expert disclosure on Monday
Okay.
from an expert who went through and analyzed the data at issue. So as
Response to the defense is having retained an expert. Who
This is,
discussed
guys, regarding cannot
whether or not
confirm
they
nor
could
can they
exclude Mr.
exclude
Kohberger from the
it
DNA
being
found on the
Brian's
evidence.
DNA
Yes.
underneath.
And what triggered
Maddie's
that was the
fingernail.
grand jury testimony where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohberger from that particular sample.
Ooh, strongly
and
exclusionary.
While that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture, and
It's just a question for the experts to testify about and the jury to make its conclusion.
Well, I think that allowing the type of questions and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under
Excluded.
you have
So
to.
you want me to believe your expert and not their expert?
Yep.
No, I'm not asking you to believe any one in particular. However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than should be the job of the defense to do. Inconclusive means inconclusive.
Thank you. Thank you, Barlow. I didn't
No,
realize
I'm not
that.
saying that. I think it can be presented, and it can be presented in a fair manner that is consistent with due process and the right of Mr. Kohberger to confront it. The new disclosure from the state is an expert who went through in great detail. We have a 27-page report from him where he not only reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's protocols and doing some validation himself, essentially looking at their validation studies.
Yes,
And he found that just visual examination of the data excluded Mr. Kohberger. He went a step further and he said, I'm going to use this new third tool called LR Mix Studio to generate the same statistic or similar statistic that the lab did, the state lab did, as well as True Allele Cybergenetics did in their analysis. And he came up with a strongly exclusionary statistic. So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000 to 100,000 times less probable that a coincidental match would be made to an unrelated person. In other words, what he's saying is that it's Mr. Kohberger is not included, and that's a strongly exclusionary statistic. And I'm not saying this very well, Your Honor, because it's a tough, these likelihood ratios are hard to explain.
Strongly
So that's a
exclusionary.
5,000 to 100,000 times less probable that Mr. Kohberger is present. In other words, it's much more likely someone else is there if there's someone else there. Then the cybergenetics came up with a number that is in the range of 2.8 billion times less probable that he is there than some other unrelated individual. And this expert then relates that even the state lab's number is 25 times less likely that Mr. Kohberger is there than some other unrelated person. So all of the numbers point to exclusion. The numbers, the question is really the weight of it.
Okay, but you can't exclude it.
The way that the state intends to present it, and they presented it in their reply to our motion, was they should be allowed to say that this means that Mr. Kohberger cannot be excluded.
It does mean
And that is just a misrepresentation of their own data. None of the data that's presented to this court at this moment in this motion supports that statement or that conclusion.
Oh my God.
And it's unclear to me who is going to say that because it's not in any of the disclosures that have been produced so far. The first time we've seen it is in this reply brief. So I think that rather than having a battle of the experts, right, where you're going to have all three of these people
I just don't want
testifying
it
before
in.
the jury, and to allow that just one question is going to subsume an enormous amount of time in explaining why it's not in it, why it's inaccurate.
Leave it out, Judge. Just
And
leave
while
it
it
out.
might be technically true,
It's exonerating evidence,
it's not
guys.
an accurate statement for the jury to consider, and it's just
I'm
gonna
sorry,
confuse them.
exculpatory.
And it's highly prejudicial to Mr. Kohberger.
It was
So
presented
we
as
would ask the
exculpatory
court
evidence.
to, if it's going to allow this in, and we haven't asked to exclude the evidence, we simply asked the preclusion of this kind of questioning, that the state be precluded from inferring or asking a question to elicit some kind of inclusionary statement.
It cannot exclude him. Can't include him necessarily, but it can't exclude him either.
I hate these numbers.
Your Honor, So let me just explain a little bit about the state's position. The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Kohberger's DNA. We just don't know. That is not what the state is trying to accomplish. What happened is the Idaho State Police Lab tested this DNA and they came up with their likelihood ratio. And that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio, anything less than 1 suggests exclusion, greater than 1 suggests inclusion. But they had done their own internal validation studies and had found that they were getting some false positives and negatives when you're close to that 1. And the range that they came up with was 0.01 up to 100. And so their policy is, if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't, uninformative. You cannot draw one way or the other, whether
Exactly.
it's exclusion or inclusion.
Can't exclude
And
or
so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Kohberger to the crime scene was on the knife sheath.
right. It was
But
exculpatory.
the analyst wasn't willing to just make that general statement because there was this issue, this
I
inconclusive.
understand it's not the state's position that that DNA is or likely could be Mr. Kohberger's on the fingernails, that it's unknown people from however the victim lived her life in the hours, days before this event, and whoever was the perpetrator may have been clothed in a way that fingernails didn't contact skin. I assume that's the state's position.
That is exactly correct, Your Honor. The state's theory here is that one would not expect the perpetrator's DNA to be under her fingernails, given the eyewitness account of what the perpetrator was wearing, the complete lack of any defensive wounds on this particular victim, the toxicology report. All of that suggests you wouldn't anticipate this to be the perpetrator. And so we have no,
So does that mean
Right.
the
She was
state's
out
not
at the
going to,
bar, the grub truck.
present this evidence in a way that would suggest or argue that it could be Mr. Kohberger's DNA? But
absolutely not, Your Honor, no. And that was part of that rather lengthy, I admit, report that was submitted on Monday was to demonstrate, yeah, when you know, the other issue to keep in mind is the Idaho State Lab uses a different program than the True Allele program that was used by the defense experts. So the Idaho State Lab pointed us to someone else they were aware of that used the True Allele program and said, why don't you speak with him? We spoke with him and he came back with the same result, exclusion. Nevertheless, given their policy, the ISP analyst is not willing to say he's excluded because their policy prohibits her. But the plan for the state, to the extent it addresses this, is for all of that information specific to her about the policy, and it fell within the policy. And that's why I'm saying that's what the state would present. And of course, she's open to cross-examination. Of course, the defense can put on theirs that can say, no, we can say he's excluded. The state has no plan or intention to in any way ask questions, imply, or certainly argue that this DNA belonged to the defendant. That,
And
again,
there you
we
go.
will actually be arguing much different than that you would not anticipate the perpetrator's DNA to be under the fingernails. And so
It was exculpatory.
that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means, but we'll stay completely away from the population of the world or a country or a city or anything about population.
Seems fair to me.
That's all. Thank you.
I know the judge is very low.
I would just like to say, Your Honor, that I guess we're in agreement, and as in an abundance of caution, I might ask the court to issue an order just that if things change,
Oh my God.
that the state has to come to the court before even trying to present such evidence.
thank you. It sounds like, and I'm not trying to tell either side how to present their evidence, that the state's not intending to present the fingernail evidence as somehow being inculpatory. I could see, based upon cross-examination, et cetera, the defense questioning the lab person in an attempt to maybe attack the credibility of the lab, which then may require the state to put on its rebuttal expert that it's identified as to that issue. But I think we're at this point safe, based on what you've said, that the state does not have a good faith basis to suggest that the DNA, to make an argument that the DNA could be Mr. Kohberger's, that they not do that without first talking to me outside the presence of the jury, based upon what the state of the facts on the ground may be at the time. As to how you question with respect to statistical analysis, I guess as guidance, it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will make sure I'm aware of the way that it was asked, in a way that was concerning, and certainly if a question is asked in a way that is concerning, the defense can object, and I can respond accordingly. All right.
Hey, Christine.
All right. Next motion to eliminate is defense 12 regarding the make and model of the suspect vehicle. Oh, I'm sorry. Did I miss one? Oh, you're right. Within the group I identified before was the touch DNA. I apologize.
Still in DNA.
Yeah.
Your Honor, this is basically a two-part motion. One is to exclude the use of the term touch or terms touch and contact, and the other is to specifically exclude an opinion of Rylene Nolan regarding the sheath DNA and her conclusions as to the how, what I call the how and the sort of when of when the DNA that was determined to be on that sheath, item 1.1. And I'll start with the touch and contact language. Admittedly, that is language that has been used for a number of years in the
Your own expert used it.
Yes, she did. And we would be fine with the court precluding her from using that term. I think what is happened in the world of DNA, having been doing these cases for unfortunately 30 years, is that there's been an evolution. And we laid that out pretty well, I think, in our papers, an evolution of DNA testing, where people started realizing the sensitivity of this methodology allows you to pick up DNA from objects that have no visible stains, like no blood, no saliva, no semen. And that led to the use of the term touch or contact, because the implication and the theory behind it was that people who touch things leave things behind, leave DNA behind. We've now moved into a world where we know that not only can people touch something and leave their DNA behind, but for instance, Mr. Nye was just standing up here. He was touching the podium. I've now placed my hands on the podium. His DNA is probably on my hands. And when I sit down and pick up my phone later, I could transfer his DNA to my phone.
Sure.
Nobody's gonna
probably also include your DNA too. Right?
Of course, but not always. And the problem with the use of those terms is that it essentially allows a conclusion to be presented through a description. And there are many, many, many ways to describe touch or contact DNA. And Ms. Nolan illustrated that in the second disclosure that was produced. And I have copies if the court does not have them. If you would like to review those, I can have them marked. And she goes through her entire discussion of transfer, which is the question here, transfer. How does DNA transfer? And how did it transfer in this case? And she does not use the word touch in describing that process. It's not essential to the description of the process. It's not essential to the explanation of how DNA moves in the environment, because many of the things she's talking about with transfer happen with any biological fluid, not just skin cells. It happens with blood, saliva, etc. So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting that the term touch DNA is usable or acceptable in the forensic community. We presented at least 3 sources that say, and these are reputable people who are publishing in reputable journals, saying that this type of language is misleading, and it can lead to a misunderstanding of the evidence itself.
So how did
because
his DNA get on the
touch
sheet?
DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from a person has gotten to an object, whether that's through direct or indirect contact.
I assume your expert's going to tell the jury all that.
Exactly.
Sorry?
I assume your expert's going to tell the jury all that.
Yes, and Miss Nolan will be telling the jury that as well as she testifies.
So what are we worried about?
What we're worried about is that it's confusing to the lay person to hear an expert use a term that is essentially a description of activity. I'm not very good at grammar, but I believe that's an adverb. And
Your
it
expert
is
can argue
not
it.
one that is useful for a jury, and it will be misleading because ultimately the experts will be discussing a much broader source of what we might call contact or touch DNA, which is anything that comes from a human being, including saliva.
They don't want to say
or
Bryan
blood.
touched the sheet.
Just because you don't
got
see
their
it,
transfer.
just because you can't see a blood stain doesn't mean it's not that stain or that area that is sampled doesn't have some other biological fluid. So it's very misleading. And it's just not necessary. And
It's not necessary.
There's a paper that was presented as a human factors report that was published last year, where the consensus, although there were 2 dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court. But it's very clear she doesn't need to use that term in her description of how DNA moves in the environment.
Oh my goodness.
So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case. As far as Ms. Nolan's opinion, again, it goes hand in hand with this idea that touch DNA or the contact DNA is not what it used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the 2 were reviewed by the 2 articles that were cited in the moving papers that say that there is really no way for a particular analyst in a particular lab to determine how and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise, which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but it's not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider, the facts presented by the state in support of their opinion, is not supported by anything other than this vague statement, well, some people don't agree with this position. We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion. And she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer in this particular case. Then when you look at her opinion, I think the court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a hand, for instance, with the object. And then she goes on to say, but because of two facts, the quantity and the fact there's a single source, I believe it got there through direct contact. She offers this court absolutely no information to support that. She doesn't.
Those two things.
I'm sorry?
Other than those two things.
Well, yes, those are two facts, but those facts and the meaning of the facts are relevant. We cited a number of cases that talk about expert witnesses and speculative opinions. And our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury, in great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can. If we were in a different place where we had some articles to support her conclusion, if there were articles to support the fact that the amount of DNA or the fact that it's a single source sample is probative of that the scientific principles and methods of DNA testing support that, then we'd be in a different place. But that's not where we are. We're here with a naked opinion with no foundational facts to support it, other than Ms. Nolan's training and experience. And while training and experience is a relevant consideration for this court, we don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think the reason is because she doesn't have any support for this. And it's going to be incredibly time-consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
Exclude it? You could present your own experts to combat whatever Nolan says.
Your Honor, I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury is not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty that this is in fact the case. Now, on the issue of the touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury. Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
So I'm not particularly fond in general of proscribing phrases and words that can be used by parties and witnesses in cases. I think it just creates the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right, in cases, and the Supreme Court has recently weighed in on that issue. There's actually an instruction that deals with the use of the term victim, because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases, I mean, we could call it blueberry DNA for all that matters, right? And your experts are going to explain what it means otherwise. What's the concern here if we say, let's try not to call it this? Other than accidental violation, and now somebody's asking for a mistrial, right? I mean, that's one of my concerns.
So in reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit, and because she uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem. And I don't think that it's something that this court should restrict. I think both of these experts felt comfortable and wanted to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something, and it's accurate to use it in this case with respect to the sheath. But certainly the state has no problem encouraging Ms. Nolan to avoid that word to the extent it's possible.
Thank you.
Thanks, Your Honor.
Just a quick response. Language is important, and language in science evolves and changes. Ms. Nolan and Dr. Ballard, our expert, are scientists. They present themselves as experts. And I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really, really important. And I am confident that Ms. Nolan can restrain herself from using that language. And I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words. And I would encourage the court to restrict the use of those words for this proceeding. As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion.
Experts can give their personal opinion.
Report to which there were dissenters.
Yes, but the dissent was not about the content of the recommendation. The dissent was, we don't have any options, and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that this testimony shouldn't be included by these people.
I'm sorry, I couldn't.
But in support of the dissent, in support of
Yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around a more like a Daubert standard.
It is, Allie.
But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
The Supreme Court has specifically rejected the Dover standard.
Well, I'm new to Idaho laws, Your Honor. That's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis this court has to do as sort of essentially a gatekeeper to make sure the jury is hearing reliable evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a single source profile would support her contention. And I think because of the complex nature of this, that we can't speculate as to why. It may make logical sense, but I'm not sure it makes scientific sense to speculate, which I think is what we are prone to do. And as I think the Idaho courts have said, the court's not supposed to substitute its judgment when for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA. As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. Science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for, I'm not opposed to giving an instruction to the jury should that term come out, that the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, I don't know, well over 100 jury trials. I think that we worry about things that they are more than competent to understand and not jump to a conclusion simply by the use of a word, particularly where there's scientific testimony around explaining what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a council at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage counsel to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect vehicle.
We don't know that. Facility, we won't know.
Your Honor, this is a motion where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number one. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number one has been referred to by the state in their affidavits for search warrants and other pleadings that they've written, where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle one to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle captured on various surveillance video shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Our request is not at this stage to limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips, that
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually factually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Franks motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are in the email. It was originally, let's look at this date range. And then he said, well, I'm more comfortable with an expanded, or we need to expand the range through 2015. And that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. And so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it? Good.
Yes, it was my motion.
Yeah. I tracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle 1 is making a specific conclusion. It's again using a term that is used within the investigation, but specifically making an argument that the various vehicles or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be right. As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back. We'll shortly before 1, but no later than 1.
All rise.
Okay. So, what are your guys' thoughts? I think the judge is politely trying to tell her that you are speaking in circles and that you can Well, and that's what it is, like, so with the suspect vehicle, one thing, the car was caught on multiple cameras, okay? Multiple cameras. But what Anne's arguing is that it's not one continuous feed, right? And so it's not like someone is going with a video camera and able to say that's the same exact vehicle. But you have to also take into account the time of night, the flow of traffic, right? There was 4 a.m. And so when you are, she's going to make the argument because she doesn't want to put him there. So there's only like one vehicle in Anne's argument that, all right, it's him, that you can see it clear enough to determine it's his specific vehicle. But you can't confirm 100% that it's in all the other ones. But here's the thing. You take the point in which you can confirm it's his vehicle, right? And then the next camera he's caught on, you take the amount of time it would take to drive from that point to the next point, and it perfectly lines up, right? Say it's 2 minutes. It's a 2-minute drive from when you can take it as confirmed vehicle to when you would expect to see it driving past this camera. It perfectly lines up. Say like same, on and so forth. Like, so every camera, like it would take 1 minute for him to hit that camera. It perfectly hits that camera. And they even explained at one point that they can see Kohberger's vehicle driving behind a truck when they're able to confirm it's his vehicle. And in that next camera where Anne's arguing you can't 100% say it's his vehicle, it's still following the truck. So it gives you a good idea. It's the same vehicle. It's like, listen, we know it's the same vehicle. Anne's just trying to argue because it's going to be much easier for her to argue him only being caught on one camera near the crime scene versus the path of travel they know that the suspect took post-murders. Is she saying the case could be thrown out because the grand jury didn't find him guilty beyond a reasonable doubt, which they don't ever do? And it's not, with the grand jury, it's not beyond a reasonable doubt. Like, they have different rules that they follow. Right. Exactly on Silent Bob. So what, and that's what it is, Allison. That's what it seems like Judge Hippler was trying to say with every single argument. They want to get it in wording. They want an order. And so with that order, they'll have power. And the judge is basically like, well, no, everything you're arguing, you will have your own expert, right? If you are nervous that Nolan is going to get up as an expert witness and talk about touch DNA, how did the DNA get there? In Nolan's expert opinion, she is allowed to say, yes, I cannot 100% say that it was direct touch from the suspect on, right? But given these factors, how much it is, and it being a single source, in my expert opinion, I'm likely to believe this is the case. And then defense, one, you're allowed to cross-examine her, but then you're allowed to put your own expert witness up to refute what that expert just said. And the jury is the fact finder. The jury is the one who sits there and determines what they believe is the most convincing based on the facts presented. I like this judge. You guys, if you've been following from the beginning, you would know Judge, bless him, but he let Anne get away with a lot. And when I say that, I don't mean like in the end she would have gotten away with it, but like there was a lot of room to play games. And Judge Hippler is not. I really like Judge Hippler because he will ask his own questions and go kind of head to head and be like, to where the prosecution doesn't even need to. Judge Hippler kind of stops it in its tracks. Yeah, he let her walk all over him. And so what's the chicken man? I think it's interesting that he was so much lower because he's tall. And he was underneath, the sea full of women. That's what it may seem like, Allison. I don't know, but I wasn't a fan of Judge. Well, and if they also, it'll screw them because their whole alibi is that he wasn't there. He was at a YYY park. He was driving maybe in the areas of the murder, but he didn't commit the murder. And so it's much easier for them to argue and play off one camera than it is all of those cameras. Yes, Oshika, exactly. Yeah, they'll be able to see him stand up, but it is very interesting the way our brain works overall throughout months. We're talking about 3 months. It starts August 11th and it's to go through November. Okay. At least I think it's going to go into December. That's just me though. It's about him sitting there and having that mental image of him small and refrained and tinier and not a threat. I don't know, Allie. Maybe just to get him in. First of all, Anne knows everything. It's open to the public. The public's going to see this. I do not know who everyone is behind. Like, I think it's not necessarily everyone for Bryan versus if you notice the specific colored chairs are open and just the benches are filled up. I think it's just a matter of how they're seating them in the courtroom. I don't know if they're all Bryan brides or what. That's true, Allison. Yeah. Yeah, it looks like some journalists, some people, they already said Bryan's family isn't in the courtroom today, but only because of the amount of financial costs it takes to come to and throw. Maybe Hartley, yeah. Yeah, because Dylan said he was, a couple inches taller than her about. Yeah, media. But, even down to the DNA, it's just, you want to get their expert, they want it out. They want completely out. This is the sheath left at the crime scene with his DNA on it. Of course they want it thrown out. It's just sitting here and nitpicking. And here's the thing. Majority of this could have come to a resolution before, but Anne didn't want, when they were going back and forth with all these motion and limines and responses, they wanted to come in and do oral arguments. This is what Anne wanted. Allie? Yep. I pray for justice too. It's going to be rough. This is going to be a very emotional trial. This is a quadruple homicide. You have 5 families, because you have the 4 victims' families, and then you have Bryan's family. It's going to be emotional all around. But I'm very curious, and I think that's good that they established any of Bryan's family that may need to be called as witnesses. They could call them out of order because they can't sit there throughout the entire trial as a witness, listening to other witnesses, and then get called as a witness. So, okay. As far as I know, he didn't put any orders versus kind of all coming and agreeing to avoid touch DNA. You could have your own witnesses. You could have your own expert regarding suspect vehicle 1. The aggravating factors with the ASD. Yeah, it doesn't seem. Oh, me too, MK. She personally believes Bryan's 100% innocent. It makes me feel like she's dishonest. I don't believe her at all, and she didn't have to go out of her way to say that. No, I don't believe her. I don't. I think she's good at what she does, but I think she is throwing up Hail Marys, and it is very obvious. If they had an alibi and they could prove Bryan wasn't there like they say they can, we would be seeing a lot different arguments being made than the ones that we are. Yeah, and then we got Lori. Oh, I have to catch up on her, but I'm not going to be able to stream the whole thing. I have my daughter's competition, so I'm going to have to get off and get ready for it, but I figured maybe I'll catch up and stream the other half. It may go into tomorrow. I don't think it will, maybe a little bit, because it seems like they're getting it done pretty quickly. But I know there's a bunch of other people streaming it. For anybody who doesn't want to wait and watch it in real time, obviously go ahead. But I'll probably stream the other half tomorrow and catch up, because I like watching it with you guys, even though I have so much to say and it's hard not to speak over. I just wish Judge Hippler's microphone was a bit closer, because you really can't hear too much of what he's saying. It's hard, Triple L, because he has the right to the best defense he can get. But when it's, I don't know, it reminds me of like Jose Baez and stuff. Like, I feel like that went way beyond the line. And with Anne, with the way that she is implying that Kohberger was essentially set up and framed, I don't like that. I don't feel like, because that is causing so much chaos. It really is. But I love, because basically everything that you've been for years nitpicking at, now it's coming down to the wire, and this isn't going to play anymore. And now when you go into trial, I do not think, it seemed like Anne had all of this control and she was doing so good. I don't think so anymore. I think now it's done. Finally, with the IGG, baby, it's done. It was a tip. We don't have to go into more about it. That's it. That's all. And guess what? Just like the prosecution said, this is the same thing we said from day one. We were never using the genetic genealogy. We were never using it. Okay? So here we are back to day one years ago we got a tip. If you think a constitutional right was broken at some point or shit was violated, you could take that up elsewhere. It has nothing to do with our case against Bryan Kohberger. And that's that. But all right, guys, I will be on later tonight when I get back from the competition with Allie to do our next part of Casey. But I'll probably just come on tomorrow and stream the second half of what's going to come on when they come back from lunch. I think they're going to be done today. I don't see them going in, but then when I think to the AT&T timing advance records, bushy eyebrows, I'm so mad I'm going to miss it all. Bushy eyebrows, 911 call, the text messages. Again, I know we were only a few minutes late, but I remember hearing them talk about Amazon. And so I don't know if they finished the Amazon. That's what we missed, but I'm going to go over all that and I'm really excited. Okay. I absolutely will. Okay. But all right, guys, I will see you soon. Have an amazing rest of your day. And thank you all for hanging out.